So let's get to CBS News legal contributor one more time, Caroline Polisi. You know, Jolene brought up a really good point, and that is anticipating an appeal like we heard about in the New Mexico case, even all the way up to the U.S. Supreme Court. You know, you and I have these conversations about how oftentimes in these court cases, things really get cemented by definition. The U.S. Supreme Court may actually end up being a part of cementing in some definitions, no?
Yeah, absolutely. And this case and yesterday's verdict, obviously watershed, not really, let's be honest, Reed, for the dollar amount, $3 million, is a drop in the bucket for Meta and YouTube. And I can tell you they spent a lot more than $3 million defending this case. And the reason they did is the point that you've been making. It's for the precedential value, because now there are potential plaintiffs out there all over the country saying, I was affected by these products. I too could win a lawsuit of this nature, and it incentivizes these companies to settle or to maybe change their tactics when they see their bottom line sort of coming into play here. The rule of thumb really is that the law catches up to society about 10 years later, and so I think we've all known for at least a decade that social media is not good for children, for their mental health, and the studies are bearing that out now. But now we're seeing it sort of trickle into the court system, and you're seeing novel new ways of trying to find liability. So the New Mexico case was a products liability case. This case was a different theory based on, like a negligent and unconscionable way to go about business practices. So there's a lot of new law being made. The question is, when will the legislature step in to regulate these companies? I think it's a wonderful verdict and a wonderful precedent for people that are hopeful that maybe we can make changes, but it's going to take some time. So for a case, yes, these cases will be appealed. Meta, YouTube will fight this with every ounce of their being, because they don't want this precedent. But I think we will see some other fields and some other issues playing out in different realms.
Yeah, it's like a million legs,
Yeah.
On a centipede. One of those legs, of course, is about the functionality, the endless scrolling, but also, we've had the conversation in the recent past about social media companies and whether they actually should moderate the content, have some sort of content protection. For instance, somebody gets doxxed on social media for whatever reason. That's content on their platform hosting falsehoods about a person, a business, an organization. Do you think that these decisions could then open up a path where people could litigate relative to the content on these platforms?
Yeah, absolutely. That wasn't at issue today, but certainly yesterday in the New Mexico case, what was at issue there, what the defense there was essentially there is a statute, a regulation indicating that platforms like these are responsible for the content that its users put out. So it plays into really a First Amendment right. But we saw really a breakdown of that statute yesterday in this verdict, because the jury ruled that they engaged in unconscionable practices in ignoring that content, right? They were aware that there were predators using their platforms to endanger children, and that they willfully ignored it. So today's verdict, again, not about that content, but about the way that this product is engineered, and it's knowingly, Reed. Okay, it's not that they just turned a blind eye to it or didn't know about it. It's that they actively understood that, and they were taking advantage of young people's sort of inexperience, their sort of underdeveloped brains, and they're rewiring really that interplay. And so when you have these endless scroll features, they know that that's an addictive feature because they want to keep eyeballs on their product. So, I think, again, we're seeing a lot play out in this field. The legal sphere is catching up with sort of, the society at large in terms of what we're seeing based on a scientific level.
Okay, we're going to keep this shot up as we look at the television. Can we put that shot back up, guys, outside the courtroom? Caroline, aside from the decision here, the verdict from those jurors, as somebody who has worked very much behind these very fancy walls, give us an idea of what's going on with the jury, because we do have this live picture there. You do see a lot of cameras, and the viewing public may not know what is about to happen for this jury. We're going to see who they are, and we're going to hear their reasoning, no?
It depends, Reed. So different jurisdictions, the judge can, instruct the jurors whichever way he or she wants, but ultimately it is each juror's independent decision whether or not to speak to reporters. As a defense attorney, I can tell you it is like gold to get a plaintiff to talk to you to see what really worked. I mean, I would be willing to bet that these companies put together mock trials and then interviewed those mock jurors to see what resonated with the jury. And so that is really, I mean, for sure, there are going to be more cases like this. And so if the defense and the prosecution can glean any information from those jurors, absolutely, they will want to get that information. And I would think that in a trial, of this substantial nature, that you would get at least some jurors willing to give interviews, willing to talk about, what their thought process was.
Whether they know it or not, they have nudged the needle and nudged the world a little bit with their decision. Once again, if you're just tuning in or watching live in the palm of your hand, Meta and YouTube found liable on all charges in that landmark social media addiction trial. Caroline Polisi, you make me smarter and walk taller whenever I'm with you. I appreciate you so much.